The affidavit and that she said she didn't feel pain. No,
I don't know. All I know
I'm
is
telling
that
you. That's why I'm up here challenging the PC on that one. There's an affidavit, a complaint that's provided.
There's an affidavit because in the
hey,
DIMS,
this is on Corral. This is a new case, right?
It's a complaint. So it happened in October 2024.
How did it get an affidavit here so quick?
Because it's a complaint. The officer's affidavit on the complaint. He states that she stated she didn't feel any pain because she was fighting him as well.
But you said that you did feel pain.
reread the complete DIMS.
I wouldn't, or that's the problem is the DIMS is maybe contradicting or inaccurate or different from the affidavit that I'm talking about. That the officer filed with the complaint.
So the complete DIMS reads, the complainant stated she did not feel pain at the time of the incident since she was fighting the defendant off of her, and that the officer observed the complainant shaking and crying, and the officer said, due to his training experience, I know being grabbed and bruises being left on her body causes pain. So according to the full DIMS, the complainant didn't say she felt pain. She said that she didn't feel pain at the time of the incident because she was fighting the defendant off of her. And that's what the full DIMS states. And the officer, based on training.
And this is the turning point. The judge acknowledges the issue, but still decides to find probable cause, leaving the door open for the case to continue. This doesn't mean guilt. It only means the case meets the low threshold required to move forward. The bigger battle would happen later, where the evidence can be tested more deeply. What do you think? Should bruising plus the circumstances be enough? Or should the complainant's own statement about not feeling pain have ended it here? Bruising plus the circumstances be enough? Or should the complainant's own statement about not
The
feeling
defendant
pain
squeezed her
have
arm.
ended it here?
And based on that, her crying, shaking, and the bruising, he came to the conclusion that she felt pain due to that being squeezed.
I mean, taken as a totality, is that not sufficient for probable cause purposes?
I don't know. You have a sworn document where she says one of the elements is missing. And then everything else that he's adding is not in that
To
document.
be more specific, she's saying she did not feel pain at the time of the incident since you were fighting. She didn't say she didn't ever feel pain. She said at the time since she was fighting the defendant off of her.
But the officer
That's not in that.
asked- But the officer never asked, hey, do you feel pain? Why
And
wouldn't you
the officer
ask?
never asked. He came to the conclusion based on totality.
Get it, but I don't know. I mean, I need to look up case law. I'm not sure. I don't know if that's enough. Because I mean, it's such a low standard for probable cause purposes, you know? I mean, I get that you're saying that it's not allegedly pain as an element, but taken as a totality.
I guess you're saying taking as a totality. I'm saying that's a lot of speculation about stuff that's not in the DIMS or in the affidavit. Like you're making all these connections.
Now the judge is highlighting the biggest weakness in the state's argument: assumptions versus facts. The officer is saying, based on training and experience, that grabbing and bruising someone causes pain, but the defense is pushing back. The report itself says the complainant didn't feel pain at the time because she was fighting back. The question becomes, can a court fill in the missing pieces? Or does the evidence have to clearly show every required
This
element?
case here, the officer never asks her, do you feel pain? He assumes she does just because of bruising on her arm. And because I guess they're in the stress of the excitement. So at the time she doesn't feel pain, but after a while, he assumes that she feels pain because of bruising on her arm.
And on bottom our camera, he never says, we don't know.
But I mean, this is a probable cause hearing. We haven't seen it. So he wants me to find no PC. If I do though, right.
Well, if there were visible injuries, we can go from there.
But he's saying that, you know, I mean, if it were like blood, like some kind of tearing of the skin, that's one thing. But bruising, is it possible to get a bruise without feeling pain?
Yeah, I do
You
it
know-
all the time. If you fall downstairs and you're embarrassed more than in pain, you might be crying or shaking because you're embarrassed or excited, but it's not because of you injuring yourself down the stairs.
But Your Honor, that also ignores that she did say the squeeze itself. He mentioning a fall, but in this case, we do have a specific statement about a squeeze.
She doesn't say that she's in pain because of the squeeze.
So
I
if we
mean-
play it out in front of a jury, you would always have that statement saying at the time she didn't feel pain. Whatever you said contradicting that, that's fine, but it would not take away that statement that eliminates an element.
That's my son.
So maybe a grand jury might find it different, but based on that DIMS, they have someone saying, I didn't feel pain. I think that's kind of like,
And Your Honor, I will say at the time, we don't have the full OR, so if you want to find no PC, we can revisit it. And if we want to re-indict it, we can.
Okay, all right, I'll find no PC.
all right.
Okay.